This video will take a closer look at what exactly lobbying is under the Lobbyist Transparency Act and answer some common questions about which activities qualify as lobbying under the LTA. Under the LTA, lobby is defined as communicating with a public officeholder in an attempt to influence any of the items listed in the definition, including government policies, legislation, regulations, programs, financial benefits, amongst other things. So, if you are communicating with a public officeholder in an attempt to influence one of these issues, you are lobbying. But who exactly is a public officeholder? The term includes more than just our elected officials. It includes MLAs and ministers and any person on that member's staff. So, for example, a minister's chief of staff would likely also be considered a public officeholder. The term also extends to employees or officers working for the government of BC, and it includes employees, officers, and directors of government-controlled organizations, such as crown corporations, health authorities, and other provincial entities. So if you are trying to influence anyone working for the government of British Columbia or a government corporation, you are likely lobbying. It's important to note that for the purposes of the LTA, the term public officeholder only includes those working at the provincial government level. The LTA does not regulate lobbying with municipal government officials, nor does it regulate lobbying with other provincial governments or the federal government. However, other jurisdictions in Canada have their own lobbying legislation and registration requirements. If you are lobbying public officeholders at governments other than the BC government, it's important to be aware of the requirements in those jurisdictions. Under the LTA, there are two types of lobbyists. Consultant lobbyists are individuals who are hired to lobby on behalf of a client. In-house lobbyists are employees, officers, or directors of an organization who are paid and lobby on behalf of their organization or an affiliate. A key point here is that to qualify as a lobbyist, one must receive a payment in connection with the lobbying. The general rule is if someone is paid to communicate with a public officeholder in an attempt to influence one of the items listed in the definition of lobby, they are considered a lobbyist, and that activity requires registration in the Lobbyist Registry. True volunteers, or those who do not receive any payment in connection with their lobbying, do not need to have their lobbying activity registered in the Lobbyist Registry. I say true volunteer because there have been instances where individuals who at first glance may appear to be a volunteer are actually receiving an indirect payment for their lobbying activity. This has come up in situations involving organizations' board members. In these situations, a board member of a certain organization may not receive direct payment from that organization for their board member duties. However, if the board member holds their position by way of a connection with a different organization from which they do receive payment, they would likely not be considered a true volunteer, and their lobbying activity would likely require registration. One question we often receive is whether sharing information with the public officeholder or providing education and awareness about an organization's programs or services is considered lobbying. This is a fine line. Strictly sharing information or providing education is not inherently lobbying. But if the communication to a public officeholder comes with an implicit request for the public officeholder to take some action, or is an attempt to influence the development of one of the items listed in the definition of lobby, then it is likely a lobbying activity. Some questions to ask yourself to assess whether the communication is an attempt to influence are whether you want the public officeholder to take an action or not take an action, as the case may be. Are you hoping to change a public officeholder's mind or opinion on an issue? Or are you seeking some change to a government program, policy, or decision? If the answer is yes to any of these questions, then you are likely attempting to influence with your communication, and it likely meets the definition of lobby. Another question we receive is whether submitting a grant application or responding to a request for proposal is considered lobbying. Generally speaking, adhering to an established government process for a grant application, RFP, or other type of funding arrangement is not considered lobbying. For example, submitting required documents as part of an online grant application is not lobbying and would not require an organization to register in the Lobbyist Registry. However, if an organization were to step outside the established government process and communicate with the public office holder in an attempt to influence the grant, that likely would be considered lobbying and would require the organization to register in the Lobbyist Registry. Similarly, if the organization lobbies a public office holder on another matter, they would also be required to register in the Lobbyist Registry. If an organization is required to be registered, they then must report any government funding they have received. In short, submitting applications for grants or other government funding arrangements may not be lobbying and would not require the organization to register. But if an organization is lobbying, they are required to register and must report information related to government funding they have received. Another question we often receive is whether all forms of communication count as lobbying. It's important to note here that lobbying can take many forms. It can come by way of face-to-face meetings or phone calls, but it can also be emails, letters, or even social media posts that tag or are directed at a public office holder. Any method of communication may be a lobbying activity if the content of the communication meets the definition of lobby. The key is not the method or form the communication takes, but whether the communication is directed at a public office holder and is an attempt to influence. One other question that comes up frequently is whether arranging a meeting with the public office holder must be reported as lobbying. Included in the definition of lobby is arranging a meeting between a public office holder and an individual other than yourself for the purpose of lobbying. So if someone arranges a meeting that involves a public office holder and a person other than just themselves, and the meeting is for the purpose of lobbying, that is a lobbying activity that requires registration. As a point of clarity, meeting requests that are not accepted or never responded to by a public office holder do not need to be reported, as they were never arranged. I hope this video helped answer some common questions around lobbying. If you have any further questions, please contact our office at info@bcorl.ca or by calling 250-387-2686. Thank you.